The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Good morning. The court has 4 cases for argument this morning. The first is 19-365, Brumley versus McDuff from Wilbarger County and the 7th Court of Appeals District.
May it please the court, Mr. Lehman will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Good morning, and may it please the court. Section 22.001 of the Texas Property Code states that trespass to try title is the exclusive method for determining title to Texas real property. The question this appeal raises, setting aside our waiver point for a minute, is what constitutes a trespass to try title action? When does it exist? And more specifically in this case, does a trespass to try title action exist when a plaintiff seeks to quiet title by pleading and proving title by limitations? Based on the long-standing precedent of this court and our intermediate courts of appeal, the answer to that question is yes. But in this appeal, the Court of Appeals disregarded the trespass to try title allegations in petitioner's pleadings and disregarded the evidence in concluding that a trespass to try title action did not exist. Instead, it honed in on the petitioner's use of the words quiet title in their pleadings. This court has long held that a suit to quiet title or a suit to trespass to try title is determined not based upon the wording of the pleadings. It's determined on a substantive analysis of the allegations in the pleadings and the evidence.
But excuse me, Mr. Lemon, but isn't usually a suit to quiet title, doesn't it presume that the party already has record title and is simply asking for a declaration that in fact that title that they already have in the records is not clouded? So in this particular case, it would have been the proper thing for the defendant to have filed record title, but there's no cloud, adverse possession, but that's not what happened. Isn't there a distinction there?
There's definitely a distinction between a suit to quiet title, primarily that it's an equitable remedy, and it relies on proving the invalidity of the defendant's deed, of the competing deed. And to answer your question directly, in some cases, record title is presented to quiet title. But the element of quiet title is that you just have to show an interest in property. And what we contend is that by proving title by limitations, we proved our interest in property. And the practical effect of doing that is that it's no longer necessary to submit the quiet title elements to the jury, because once you prove adverse possession as a matter of law, that essentially quiets your title. And
so the distinction between, already, quote, having title, at least as according to the records, and having to prove that you have title by limitations, adverse possession, whatever, is really a distinction without a difference, right?
I would say so. I think the distinction becomes relevant under certain factual scenarios. And in fact, I would go so far as to say most fact scenarios, a person quieting title has record title. But what this court has never held, as far as I can tell, is that the two actions are mutually exclusive. And specifically that you can't quiet title by proving title by limitations, as was the case here. And I suspect one of the reasons why it's made it to this level is the fact that the court hasn't really opined on this issue for many years. I think that the court has definitely opined on the distinctions between a quiet title and a trespass to try title action, I believe most recently in 2018. But I don't think this court has ever held that the two actions are mutually exclusive. And 12 out of our, as you can tell from our briefing, 12 out of the 14 courts of appeals have adopted the precedent that this court established in basically the 1850s, that the form of the pleadings is not dispositive of the issue. There are no magic words. You don't have to say trespass to try title is what I'm suing for. I think Longoria versus Lassiter, which was a 2019 San Antonio Court of Appeals case, stated the precedent most succinctly. And they said that a suit to resolve a dispute over title to land is in effect a trespass to try title action, regardless of the form the action takes and regardless of whether legal or equitable relief is sought. And that's the point that we're making here. And
Mr. Lehman,
Sure.
nevertheless, there are nuances between the respective actions, and as a matter of, I guess, fair notice, when you're trying the lawsuit, why would someone expect you to be trying the claim that you're trying when you didn't plead it and squarely and directly? So, I mean, how did you all get ready for suit if you were proceeding on two different types of claims?
In this case, it was very clear from the record that both parties knew exactly that title was before the court. And the reason I say that, to answer your question, first of all, plaintiffs or petitioners pled all of the elements of a trespass to try title claim. All the elements of adverse possession are in that petition, the same way as you would try any other trespass to try title claim. In fact, if you took out the words quiet title, nothing would change if pled as a pure trespass to try title claim. But the other thing that's apparent for the record is not only did petitioners allege trespass to try title, defendants allege trespass to try title also, and their answer to our petition was that they pled not guilty under Texas Civil Practice and Remedies Code, Section 788, which is your standard trespass to try title defense. They asked for an abstract of title, which you typically do when a trespass to try title claim has been pled. And they also claimed adverse possession in addition to record title. And so what's been baffling to me in this case is how the Court of Appeals can say that title was not before the court here. It was not only here as pled by petitioners, it was pled by respondents as well. And the reason I think that's important is
let me just ask you before you get to that, and please remember that, but why didn't you just amend your pleading to specifically request, the magic words?
That's a good question. In hindsight, it probably should have happened. But we felt like the claim had been pled when we pled the elements of adverse possession. And I think another thing here is it's pretty clear from reviewing the record and the pleadings that plaintiffs were not seeking the quiet title in the equitable sense, in the traditional equitable sense that we discussed earlier. I think the phraseology of using the term quiet title interchangeably with resolving a dispute to title to real property is definitely a factor here. And I think that if you apply the applicable standard, then it becomes pretty clear that the that title was before the court, and regardless of the words used by the parties here. And another thing that I think may have tripped up the Court of Appeals, for some reason, the Court of Appeals was hung up on its opinion in the fact that there was made reference to competing deeds to the property. And that is, in fact, something that is in our pleadings as well. Petitioners did receive a deed to the property. However, it was made abundantly clear, in not only in pretrial, but multiple times throughout the trial, including the charge conference, that petitioners were not seeking the quiet title based on the strength of the deed that they had. In fact, the only reason the deed was even relevant in this proceeding was it was evidence of why petitioners were on the property to begin with, why they were asserting the claim. And so I think that's something that the Court of Appeals missed there. And
Mr. Lehman, on the, of course, we have the general Boyles versus Kerr standard that you can infer a cause of action by looking at what the petition states. But how does that apply when you have specific rules about how a particular cause of action has to be pleaded, like we do here in Rule 783 to 809 for trespass to try title? What do we do with those rules if you're right about how this case ought to come out? Do people just basically not need to look at those rules, or what's your what's your thought about what their continuing role in a trespass to try title case is?
I think the rules set forth in the Civil Practice and Remedy Code are the elements you have to prove. And as far as the pleading requirements, I still think if you proceed under a trespass to try title theory, that you have to plead the case in accordance with those rules. And we felt like that we did here. And I think it goes to the essence of what the standard of review is. You really look to the heart of what the issue is. Is it about title? And I think those elements, especially in the case of adverse possession, I mean, if you still have to prove the elements of adverse possession as one of the 4 ways of proving trespass to try title. And I want to speak a little bit about the Ammerman case that this court issued, and that was not only cited by the Court of Appeals, but also respondent's opinion is that this case is inapplicable entirely. I think that case is a good representative case of how the court looks at the issue when a question about whether trespass to try title has been raised. And in that case, of course, it was a declaratory judgment, but the court found that claim was a trespass to try title claim in nature, and title was adjudicated in that case, even though statutory trespass to try title had been non-suited. And so I think that really underscores the standard of review. And I want to speak a little bit about our first issue in our brief about the fact that this issue was not raised on appeal. And I think it's dispositive of this case for this reason. And that's because the failure of the pleadings, the deficiency in the pleadings is not fundamental error as this court has determined. This court has recently outlined the test for determining whether fundamental error exists in USAA Texas Lloyds versus Menchaca. I believe that was in 2018. And fundamental error has been condensed, according to this court, to essentially 2 things, things that directly and adversely affect the public interest, and that affirmatively and conclusively establish that no subject matter jurisdiction exists. As we've already discussed, title was clearly before the court, giving the court subject matter jurisdiction over how to handle this appeal. I think the fact that it was not raised in the briefs, there were essentially two main issues, error assigned in the briefs. One of them was a legal and factual sufficiency attack of the evidence of adverse possession. The other was the denial of certain jury questions and instructions that had been requested by respondents. Neither of those issues, as you can tell from the briefing, alleged that the cause of action was incorrect, that this should have been a trespass to try title case instead of a suit to quiet title. In fact, as we mentioned in our briefing, the words quiet title don't even appear in the briefs in the Court of Appeals. So,
Mr. Lehman, on the second error brought before the Court of Appeals, there was a line that the trial court erred in submitting the case on an improper theory that was curable only with the question demonstrating who held record title. Does that fairly, as a subsidiary issue of their second ground for appeal, does that fairly bring that question before the Court of Appeals, allowing the Court of Appeals to make to reach the determination that it did?
Absolutely not. And the reason I say that is because if you go look at the record in the context that objection was made, the objection was to submitting adverse possession to the jury under the guise that defendants had record title. Respondents were disputing the fact that we had put on evidence of the deed. And so their position was that the jury could have been confused unless there was some kind of instruction or question on who owned record title. And of course, our argument to that, our response to that was that record title is irrelevant if we prove adverse possession, being that would trump. So no, that objection had nothing to do, primarily or as a subsidiary question with the issue of whether the pleadings alleged the correct cause of action. And if you have any other questions, I'll reserve the remainder of my time.
Any other questions? Thank you, Mr. Lehman. We'll hear from the respondent.
May it please the court, Mr. Cummings will present argument for respondents.
Mr. Chief Justice, may it please the court, good morning. The ultimate question posed today to this court is whether it is prepared to merge quiet title and trespass to try title, and in effect lower the bar for pleading a trespass to try title claim for title by limitations. This in spite of the fact that the petitioners in their pleading at the trial court that was live at the time of trial pled on no separate than 5 different occasions that they were bringing an action for quiet title. And now they seek to ask you to convert that pleading that says quiet title into a trespass to try title and adverse possession title claim. They're in effect asking you to lower that bar, and this court should not accommodate that request. And it shouldn't do so for a very important reason. The right of land ownership in this state is one of the most essential and cherished rights. And before we take away a lawful possessor's land, you have to meet a very high bar. It's why adverse possession is so strongly disfavored in our law and in the law of many other states, and why such a high bar is set. Mr. Lehman took in reverse
Mr.
order.
Cummings,
Yes, ma'am.
it's strongly disfavored, and but can you try it by consent? Do you disagree that you could try such a cause of action by consent?
It could have been tried by consent, yes, Your Honor, except that as the Amarillo court pointed out, there was an objection to the charge, and the Amarillo court specifically addressed that issue as part of its opinion, noting that this case was not tried by consent. But you're correct. Had that objection not been made, then it certainly could have been, yes. I'd like to take then in reverse order Mr. Lehman's arguments in the same way that he did. And let's move to that second issue presented, because the Brumley's pleading of quiet title cause of action does not support the judgment entered. And the Amarillo court properly found that as a result, the judgment of the trial court could not stand. If a plaintiff wants to plead trespass to try title through adverse possession, then as properly noted in one of the questions earlier, there are specific rules that set forth what must be done. Rule 783 through 809 of the Texas Rules of Civil Procedure. We specifically treat this different than we might in other occasions where notice pleadings or more liberal rules might apply. And that goes back to the point I was just making. Adverse possession is such a harsh remedy that before we dispossess a lawful owner of their land, and not to get too deep into the weeds here, but in our case at least, my clients are an elderly couple and their 2 daughters. We're talking about their retirement nest egg here that is essentially being taken away from them without compensation. And so that is why when adverse possession is in the case, we talk about such a high standard. You have to plead it specifically, not to get too technical, but cross every T, dot every I. And in this
Mr. Cummings, which element of adverse possession required to be pled was missing from the pleading?
Well, I think as the Amarillo court pointed out, while allegations of adverse possession were made, no mention was made of any adverse title claim, and no other claim or cause of action was identified. And if you look at Rule 783,
Did the petition use the word adversely possess?
it did not. In fact, you'll find that in the petition, they did not use several words. The words trespass to try title, the words adverse possession, or title by limitations do not appear in there. Now, I will concede that they have a section, and if you look in the clerk's record at section 6.2 through 6.6, they appear to have allegations of adverse possession, and that's what the Amarillo court refers to. But they don't use the words adverse possession. They don't use the words trespass to try title.
They say something about having a suit to adversely possess. They use the word adverse, and they use the word possess.
An adverse suit, yes, Your Honor. And I think the
Adverse
problem,
suit to possess, something like that.
yeah, the adverse suit to recover the property is the words they use. I'm looking at their petition. But I think what the Amarillo court did here, Your Honor, is they took them at their word. In 5 different places, they say that they're filing a suit to quiet title. They begin in their venue section saying this is a suit to quiet title. They then in their facts section talk about purchasing the property and having a deed. And they end their facts section by stating first that the McDuff's claim is a cloud on their title, And second, that they bring this action to remove the cloud on their title and to quiet title to the property. They then conclude their pleading by arguing that they are seeking relief of quiet title. And this is where we get back to Rule 783 to 809.
Excuse me,
Because if you look at
excuse me, Mr. Cummings, but even if they were to use those other words, if within the pleading, they are communicating the request that the court find because of the adversity that exists, that they're entitled to title, that they have title to this property. Does it matter that those other words were used also?
It does in this context, yes, because when it comes to trespass to try title, we have specific pleading rules that have to be met.
Well, that's
So-
not my question. My question is, let's say if those pleading rules were met, then what does it matter that there were other words there as well?
Well, I think it would matter if they had, for example, alternative pleadings. So if, for example, they brought quiet title and alternatively trespass to try title, what they're essentially asking you to do, Your Honor, is merge these two claims into one. And these have always been two separate claims at law in Texas. Quiet title is equitable relief. It has different elements. Trespass to try title is, of course, legal relief. It's title and also has different elements than quiet title. And so in effect, what their pleading seems to do is almost create a jambalaya of trying to bring two claims as one. And when you're talking about trespass to try title and a title claim, it needs to be specifically pled. If you look, for example, at Rule 783, you've got problems both with element C and element E under Rule 783. In terms of element C, for example, what you've got is they don't directly state their interest claim. That goes to the question that was just asked about title by limitations. They don't say this is trespass to try title or title by limitations. And element E that talks about making a prayer for relief, they don't pray for title by limitations. They pray for quiet title, which is a different form of relief. So even if we were to
Did they
assume,
plead that the limitation, that they met the limitations period by occupying the land during the limitations period in two different allegations?
they do include that in their, where they do have the allegations of adverse possession. Yes, Your Honor. But they don't actually pray for that relief. They pray simply for quiet title. And the issue, as the Amarillo court properly pointed out, is those are two different causes of action. And while you may have allegations of adverse possession, if you're not bringing an adverse title claim, if you're not specifically stating it, we're going to hold you to your word. And I think that's really the issue here. The Amarillo court held the plaintiffs to their word. They said on 5 separate occasions, we're bringing a quiet title claim. The Amarillo court said, okay, we're going to look at that and say, in bringing a quiet title claim, you didn't meet the elements you needed, and therefore you don't have a judgment that's supported by the pleadings.
In a quiet title claim, is it atypical to have pleading assertions that relate to adverse possession? For example, I think if they were claiming title, they would sue to remove the cloud. And would it be atypical to include the magic words that they seem to have sprinkled throughout their petition here, their pleading?
I think that had the plaintiffs pled quiet title and listed the elements of quiet title, and then alternatively pled trespass to try title, and then pled those elements, and then in their prayer for relief properly pled for the 2 alternative forms of relief, that would certainly address what Your Honor is talking about. And I believe there was a question.
Go ahead.
I believe there was a question earlier that talked about, why didn't you make a trial amendment? This objection was made on the record. It was also made incidentally at pretrial. And the Brumley certainly had every opportunity to do a trial amendment, to amend their pleading and make it clear this is not a quiet title as our petition claims, but instead is trespass to try title. And I think that's what the Amarillo court really was focusing on here. And
Cummings, what would the role be of the language about adverse possession that's in the pleadings, the various elements of that are in there? Do those allegations also play a role in a quiet title claim, or are they solely referable to an adverse possession claim?
I think at the end of the day, if you're arguing title by limitations, that's a trespass to try title claim. Quiet title is equitable. Quiet title assumes that you've got title that you can trace, and you're going to have to meet the various elements that are set forth as a specific equitable quiet title claim. But here, it's clear they're claiming title by limitations, or at least attempting to claim title by limitations, and they've simply brought the wrong cause of action. In some sense,
is there any, what I'm asking is there any role that those allegations would play in a quiet title suit? Or do they just show that they're also trying to bring a trespass to try title claim as you suggested, but they didn't dot all their T's and cross all their T's and dot all their I's?
well, I think when you look at the four elements of the three elements of a quiet title claim, our elements obviously are the plaintiff has an interest in the property, the title is affected by a claim, and the defendant's claim, though facially valid, is invalid or unenforceable. You really can't get to title by limitations with that third part about the defendant's claim, because our claim was valid and enforceable, but for, if they're going to claim title by limitation, some trespass to try title. So as the Amarillo court, you really said you really can't get to quiet title with this and the exclusive method. And I think that's been the law in Texas for a while, all the way back to Haskins v. Willett, that the exclusive method.
Does it matter, Mr. Cummings, that the disputed land in this case emerged through accretion? So there is no title with a defined boundary to this land. In other words, there is no title because it's land that emerged through accretion, and both and probably establishing title by reference to a deed alone would be difficult to do because there's no meets and bounds or boundary description.
To some of the land, perhaps, Your Honor, but that's going to be down by the Pease River is what I think Your Honor is referring to. But a significant portion of the land certainly is within the original meets and bounds. And so that then gets, I think, into the issue that we're going to talk about in our cross point, which is the fencing and the fact that you had fencing that was there that predated the Brumleys coming on the property. It's undisputed that some of the fencing was untouched by the Brumleys, that there was a gate that the McDuffs had that was at the northern end of the property where the McDuffs' home was, that continued to have the McDuffs' lock on it, that they could enter and exit through that gate without any hindrance, that they continued to use the property. There's, as our cross point points out, substantial use of the property here. And I don't want to jump too far ahead, but one of the points that we make in our brief is, even if you feel that the Amarillo court is perhaps being too harsh here, and we don't think they are, we think adverse possession is a harsh remedy against our client, and the Brumleys do have to cross every T and dot every I. But even if you feel that, there was still legally insufficient evidence even to support if they got to the adverse possession. And that goes to that gate, that goes to the fact that my clients were not prevented from getting on the property because the fencing at the northern end was still their fencing. The gate was still their gate. The lock was still their lock. They actually went on the property and used it for marketable purposes. They picked plums that were then sold at market. So there's significant evidence. And of course, there's the case out there, I think it's Terrell versus Tuckness, that says it doesn't matter who uses the property more or uses it best. It just matters if there's joint use. And if there is, you can't get to adverse possession. I do want to jump back just very quickly to the first issue and make sure that I address it. And I think that there's a couple of points that I want to make sure are covered here today. First and foremost, the Amarillo court clearly felt that our briefing raised the issue and that by raising the issue of submission of the case to the jury, this issue was fairly considered within it. As was noted earlier, there's a direct quote from our brief that talks about an incorrect submission of the jury. But had the Amarillo court felt that additional briefing was necessary, it certainly could have done so under Rule 38.9, right? And further, and I want to make sure that I at least put this out there, 38.1F says that the statement of an issue or point will be treated as covering every subsidiary question that's fairly included. I don't think there's any doubt that the issue of a proper submission is fairly included within our objection to the submission here. Now, petitioners argue that the words trespass to try title did not appear quiet title in our brief. But as this court noted in First United Pentecostal, a party sufficiently preserves an issue for review by arguing the issue's substance, even if the party does not call the issue by name. And as this court noted earlier this year in St. John Missionary Baptist Church, even when certain words are not used in appeal brief, if the issue is a subsidiary question fairly included, then it's sufficient to put the Court of Appeals on notice and invite the Court of Appeals to correct an error of law. That's clearly what the Amarillo court felt. And if they hadn't, they had the option to ask for additional briefing. The Brumleys at the Amarillo court filed a motion for rehearing, put these same arguments before the Amarillo court in their motion for rehearing, and that was denied. Had the court felt that additional briefing was necessary, it could have done so then. And I think it's also in line with this court's holding in United Scaffolding that talks about issues that are raised by the written pleadings and evidence. We objected to the submission, both at the trial court and in appeal. And I think it's important to note here, because there was a question early on about whether quiet title and trespass to title are a distinction without a difference. But these are two distinct causes of action. There's no argument that one is really a subset of the other. There's an extensive line of case law, and I believe even Mr. Lehman conceded in his argument that the appropriate method of determining title to land in these instances is a trespass to try title. It's also plain on the record, they did not plead it squarely and directly. They did not make a trial amendment when those issues were raised. And as a result, the Amarillo court held them to their word. I want to emphasize again, 5 different times in their pleading, they say this is an action to quiet title, and they seek the remedy of quiet title. And they invite this court to mix those two claims together, to lower the bar for what it takes to plead taking someone else's lawful land. And we would ask the court not to do that. I do want to turn here at the very end to our cross point, which is that even if this court finds that somehow the pleading was sufficient, there was still legally insufficient evidence to support the jury's verdict. And I would note initially that this court in McKelvey versus Barber did hold that when a case comes to you, obviously the losing party only need bring forward the other issues. But if there's an issue of law or a point of error that warrant affirmance of the judgment, not considered by the intermediate court, and it's a point of law, you can do so. You went on to say that while remanding might be appropriate, if there is a point of law, you can rule on it. And Willis versus Maverick in 1988 said that same thing, which was that you can reach a point of error that if there was legally insufficient evidence to support the jury's verdict. And I've only got 2.5 minutes here, but I'm going to run through very quickly why we think even if you reach their pleading as adverse possession, they still don't get there. A claimant's exclusive possession and hostile appropriation of land must wholly exclude the record owner. That's one of the elements they have to prove. And as we showed in our cross point, and particularly if you look to the map that we attached to our brief, there was significant fencing that was not either repaired by the Brumleys or put up by the Brumleys, but in fact predated them. And the biggest point I want to make is that there were gates that the McDuffs constructed by the northern edge of that property that were not changed. The locks were not changed, and through which the McDuffs continued to enter the land. The Brumleys didn't cut off those locks, and that's undisputed testimony. It's also, the court also heard testimony that the McDuffs went on the land multiple times. And I want to address, there's 4 different owners here. There's the 2 elderly owners, but there's also their 2 daughters and their husbands. And there was significant evidence, particularly of one of the daughters, Erin Oliver, going onto the disputed tract whenever she wanted to, that she would go down there to pick wild plums that were then sold at market. Her husband, Casey, drove ATVs, shotguns, and hunted on the disputed tract. He went camping down there. There's also testimony, and we've got all of these references in our brief, to the multiple times that they would go down there onto the disputed tract, at least 20 or more times for hunting. Mackie McDuff, the other daughter, went down there hunting. And I suspect what you're going to hear from Mr. Lehman is that the jury had the opportunity to hear that evidence. But what was undisputed was that the McDuff's gate, the lock on that gate, continued to be the McDuff's, that they weren't locked out of that property, that they continued to have access to it. And the last thing I would want to bring to this court's attention is this issue of casual versus design fence. And that was one of the points in our brief below, and also a strongly contested point at the trial court. It's clear that the Brumleys did not build an entirely new fence around this property. Rather, they tied into fencing that predated it and did not do any changes to certain of the fencing. And if we're talking about notice to a record owner that they're going to be excluded, the fact that you don't remove their locks, the fact that you don't change fencing, particularly on that northern edge right against the McDuff's property, is certainly not notice to the record owner that you are excluding them. And then when that record owner goes on so many times, as each of the 4 different owners testified, that simply doesn't get you there. So we believe this court should not accept the Brumley's invitation to lower the pleading requirement, but that the judgment below should be affirmed. Thank you, Your Honors.
Any other questions? Thank you, Mr. Cummings. Mr. Lehman, you have about 6 minutes.
With regard to the evidence of adverse possession, I think the evidence speaks for itself. If the court gets to that issue, I think it'll find there was overwhelming evidence, but I won't go into that unless the court has specific.
I just have a question. Do you disagree that they were not excluded from access to the property during that period of time? And the record will bear on that, but do you disagree that the jury heard conflicting evidence on whether they were in fact excluded completely from access?
That's an incorrect statement of the record. The record reflects that they were, the gates were either obstructed by the growth of trees or they were locked out with locks, and that's evident in the record. But to address specifically, there's a lot of focus by Respondent's counsel on, again, the use of the words quiet title in the pleadings. And I think that's the same mistake the Court of Appeal made. Taken to the extreme, it doesn't really matter under the applicable standard review what we called it. We could have referred to it as a claim for gross negligence. But if the elements of adverse possession of trespass to try title are there, and it's clear from the evidence put on, which in this case, the only evidence put on was on adverse possession. The evidence of who owned record title was specifically excluded by the court in this case because the trial court recognized that adverse possession would quiet the title, would resolve the issue as to record title. And so when that's the case, you have to look at what the heart of the issue is, and the heart of the issue here was clearly title, irrespective of what the form of the pleadings say, and that's directly on point with what this court and our intermediate courts of appeals have held. With respect to the objection that was made and the question of whether the issue was tried by consent, of course, I don't think I've already addressed the fact whether there's a subsidiary issue raised in the briefing before the Court of Appeals. But going back even further into the trial court, the objection that was made was not that adverse possession was an improper theory to submit to the jury. The objection was that it shouldn't be submitted without also a question on who owned record title, because the concern of respondents, and again, this can be determined by reviewing the charge conference. The concern was that the jury would think that the Brumley's deed somehow gave them title, and therefore that would weigh in on their decision on adverse possession. And so there were at no point was the fact that this was really a quiet title instead of an adverse possession, a trespass to try title, that the wrong cause of action had been alleged. That was never raised. And it's also, I don't see how a respondent can deny the fact that when they answer with trespass to try title defenses and demand an abstract as you would in a trespass to try title case, a trespass to try title was clearly the claim alleged, and everybody knew it from the day the pleadings were filed. With regards to the judgment, there was a reference that the judgment somehow didn't comport with the pleadings. We also disagree with that. The judgment specifically said that adverse possession having been found by unanimous jury verdict, title is hereby quieted in the name of petitioners. And, I think the analysis of what was being argued, quiet title was not being used in the traditional equitable sense, although it clearly removed the cloud on title. And I think that's something that this court should keep in mind. It's never been held that the two actions are mutually exclusive. One way to quiet title would be to prove adverse possession. And that's what we did in this case. There's other ways to quiet title, but should have been pleaded more clearly. I don't think there's any question about that, but it was not a fatal defect under this court's precedent. And for those reasons, we would ask that the Court of Appeals decision be reversed and this matter be sent back for review of the issues actually pled on appeal. Thank
Are
you.
there any consequences that would flow from your rule? Taking property from Texans, through adverse possession is a harsh remedy, and bad facts make bad law. Can you see any consequences flowing from your proposed rule of, looking at the pleadings very liberally to arrive at, a proper pleading of such a harsh claim?
Well, I don't think so, because the bottom line is here, we still had to prove trespass to try title. We still had to prove title by limitations. We're not advocating that standard somehow be lowered in any form or fashion. We pled the elements, we put on the required evidence, and that will continue to be law until this court or the legislature says otherwise. So no, I don't see this as changing any standard of review, other than recognizing one way to quiet title would be to prove adverse possession.
Any other questions? Thank you, Mr. Lehman. The case is submitted and the court will take a brief recess.